the option. You're saying, hey, you can do what you would have done regularly anyway, but what I've given you is this big gift on top of that that gives you the option at least of keeping this thing locked down and safe so that it can't be taken away from you. Okay. All right. Summary. We've got you're not dead at all, but incapacitated. We've got your wills and trusts that protect your children, whether they're minors or adults, and appoint somebody to take care of your young children. And then we've got, I guess not listed there so much, but also your living will that kind of gets you in that not dead yet scenario where you can give instructions for how you'd like things to go. And maybe I didn't touch on this, but this is that case that was made so famous back in Florida with Terry Schiavo, where she's in a coma. They don't think she's ever going to wake up. The doctors have said she's going to pass, but we're just waiting. Parents said something to the effect like, hey, when she talked to us at Thanksgiving, she said that she wanted us to do everything we ever could if she got into a situation like this. And then the husband said, well, we talked at Christmas, and she told me she wanted us to pull the plug and didn't want us to drag her life out like this. And since there was no written document from her that could be decisive, it was put before a judge, and it drug on for months and months and months while mom and dad and husband litigated against each other saying she wanted this, no, she wanted that. And that whole scenario could have been avoided by a written document called a living will that basically says, here's what I want. And you have three options. Okay, one is pull the plug, leave me alone, let me go. If the doctors have certified that I'm going to die anyway, and that's the only situation where this comes up, is that they know I'm going to die anyway, it's just these machines that are keeping me alive, I want you to take me off of everything. The other extreme is that you can say, I want you to do everything in medical modern science, including freezing my body if you have to keep me alive, because there's always hope, and I'm an optimistic person, and I think things will work out. And then you've got a middle option that basically says, I want you to do this, but not that. And generally what that option entails is saying, I don't want any machines, I don't want a breathing apparatus, I don't want a feeding tube, but I don't want to die hungry or thirsty. I just can't abide the thought of that. I want you to keep the IV in. Don't let me starve to death. Don't let me that be the way that I go. But keep the food and water going through the IV, and then take me off the machines and let me go naturally. And I think I can deal with that. And that's what I'd like to have happen. Maybe that'll prolong my life a little bit, but you know, at least I go naturally and I'm more comfortable that way. There's not any one of those three options that we recommend. It's different, it's a personal choice, but the important thing here is that you've got to do something. You've got to make a decision. And there's a mercy element to that, because not only are you telling the judge and the courts, hey, look, this is what I wanted, but you're also taking a huge burden off your family members. You know, you may trust your spouse, like I trust my spouse emphatically to make those decisions for me, but she's going to have to live with it the rest of her life that it was her decision. It was probably the right decision, whatever she decided to do, but it was her decision. If I've left a living will for her, then it's not so much her decision as her just honoring my wishes. I made the decision. I took the control. I decided how I wanted it to happen, and she just respected that. And can you feel the difference between how that would be if you were in that situation? So this is kind of a package deal that we put together for folks, is that we always put the power of attorneys in for health care and finances. We put in a living will, and then we create a will or a trust, depending on what you need. Prices start anywhere from about $300 on up to $6,000 for the really complicated tax planning. What you need depends a little bit on your individual circumstances. And when you're paying us the money, you're not so much paying for the documents that you get. And it's no secret that we've got computers and that we can produce these things pretty easily. What you're paying for is an attorney to sit down and analyze your individual circumstances and say, here's a red flag, here's a problem, here's an issue that you need to address, and here's what could happen if you don't take care of it a certain way in your will. And if you've got a traditional family where you've been married one time and you've had kids together, and there's no kids from other marriages, and there's no kids that have financial problems, and they're not minors or whatever, we will honestly tell you, hey, look, you may not need a will at all. The state of Idaho's statute works for you, and we're happy to do that. But if you're in a situation where you've got some specific issues that need to be addressed, we can customize your will in a way that addresses those and makes sure that you're taken care of. And again, we fully recognize that this doesn't benefit you directly, but that it is an act of love and concern for your children and folks that come after it. That's all I've got. I think we're close to being out of time, but if you've got any questions, I'm happy to address those now. Anything coming up as we're speaking?
So
Sure.
how soon should you get a will, and how often do you have to revise it or update it?
You know, the hope is that you won't ever have to revise it or update it, but my personal experience is that a will lasts really effectively about 5 years, and then has gotten really stale and I wouldn't need it anymore after 10 years. You know, and the reason for that is that there's just so many circumstances in life that change over that kind of time period that you can't, without a crystal ball, you can't anticipate what's going to happen. And 10 years from now, you'll look back and you'll be like, I could have never guessed. You know, if you look back 10 years right now and think where you were 10 years ago, it's impossible to see what the future's going to hold. That being said, one of our primary focuses is that we want flexibility built into the will. And that's one of the things that we guide you through in selecting your conservator and your guardian and your trustee and whoever you're going to fill these roles with, is that we want to keep it flexible so that that person can analyze what's happening in the future and say, you know, she said that she wanted us to go to college, but now that the government has socialized college and it's free to everybody, we're going to use the trust for something different, or whatever ends up coming up. Did you have a question, Mike?
Yeah, what, you know, you talk about having the guardian and all of that to manage the money so your kids don't have to worry about, you know, the two hats. What if the trustee just starts to become difficult and won't give the money when it would be appropriate, things like that? What kind of steps would the children have?
Well,
say, hey,
James is handling a case like that right now, and it's really contentious because Dad gave everything to his best buddy, who he thought he could trust emphatically, and best buddy took the money and moved to the East Coast and started spending it as fast as he could. And it took daughter a little while to figure out that that's what was happening, but there is a set of laws that allow you to go into the courts and get a judge to put a stop to that. And like I said at the beginning, that person that fills the role, when you select them, they're a fiduciary, which is a legal term that basically means they can't act for themselves. They can't use that money on themselves. That's not to say they won't, but it becomes a crime, and the judge can punish them for it. He can take the money back. He can appoint somebody else that they trust to put into place. In this situation, we're trying to put the daughter in to be her own trustee, because all the money's really for her anyway. And you know, it's unfortunate that Dad made a mistake like that. He thought he could trust his friend, but it just didn't work out that way. So we've litigated that for him, and we're in the process of changing her into the position of the trustee and trying to recover some of that money that he's blown through. Yes?
My husband and I have wills with power of attorneys and living wills. They were done probably 10 years ago. And,
Sure.
Where do you suggest storing them? We have an original, we have a copy, and we've selected someone to act as the guardian and so forth, but what do you do with your original and your copies?
You know, I don't have a specific recommendation. I've got one place that I just absolutely say don't put it there, but for the most part, what we want is the will to be stored in a place where it can be found. Okay, so often a bookshelf is a good place if you put it in a binder. Often there's a drawer in a desk where you keep important papers. You don't necessarily have to tell your kids, hey, this is the will, and let them look at it, but you can tell them, hey, I keep my important documents in this place, or there's a safe, and here's where the key is. If something ever happens to us, you can go and find it there. The only place that I don't want people to put their wills or their trusts or other documents is a safe deposit box. It seems to be the go-to place that most people think of as the most safe there is, but the problem with that is, say my parents put their will in a safe deposit box, and then they tell me, hey, it's in the safe deposit box, if anything happens, let's go get it. Well, they both go down in a plane crash on their way to Hawaii, and I go to the bank and say, I need to get the will out. The bank will say, that's fine, but you don't have any authority to get into that safe deposit box. You need to go get appointed as the executor